Hello, everyone. Thank you for coming out today for our Book Sandwiched In. This is one of 2 June Book Sandwiched Ins. I'll get to that in a minute, but we are happy to have everyone here today for our second Thursday program. My name is Dina Viviani. I'm the programming librarian here at BML. And just to start with a few housekeeping announcements. First, if there is a need to evacuate the building, the door on my right, your left, is our closest exit. For anyone who uses a hearing aid, we invite you to take advantage of our induction loop system. It will amplify all sound coming through this microphone. And along those lines, if we have time for Q&A at the end, please wait until this microphone reaches you so that everyone can hear and participate. Please silence or turn off your cell phones now so as not to disrupt the speaker. And we'd like to thank the Friends of Brighton Memorial Library for sponsoring this program. Please check out the bookstore in the rear of the library for any good deals to be had. The money comes back to support all of us and our programming. And we are hard at work planning our next season. We've got some great speakers and titles lined up. We're not fully done yet, but we will be kicking off again in October. And then we had rescheduled our Kristen Hanna, the Women Talk with Judy Leone, who is from the Veterans Outreach Center. So she was able to reschedule. So she will be here in this room, 12 o'clock Thursday, June 26th. It is in our June program brochure, and we've updated it online in case you need a reminder, but we hope that you will join us again for that postponed and re-planned program. And now I will introduce today's speaker. We are happy to have the Honorable Karen Morris, retired Brighton Town Justice after 29 years. She is a professor of law and business at Monroe Community College, the author of legal articles, textbooks, and more, and she was Citizen of the Year, got the award from the Brighton Rotary in 2023. And I had a lot of questions about this when I worked the reference desk last month. People wanted to know where Karen Morris was discussing The Trial of the Century by Greg Jarrett, and that was at the JCC. And we have had her here for numerous book reviews for our own BSIs over the years. We enjoy hitting her up for her take on crime stories and mysteries. So without further ado, the Honorable Karen Morris. Thank you.
Thank you. Thank you. Thank you, thank you. Good morning, good afternoon, I guess. We just are over the noon. This was a difficult book to review. It is, of course, The Frozen River, and it is by Ariel Lawhon. It is, at its core, about a midwife in the state of Maine in the late 1700s who felt strongly and ahead of her time about women's rights, also about children, about love, about fairness, and about evening the score. Stated differently, she wanted to ensure that the scales of justice were evenly balanced, particularly in reference to women's rights. And so I thought it very fitting to bring scale of justice, and my goal is that it be evenly so let's just make sure that is the case. There we go. So there's so many tales woven into the story and so many characters that it makes it hard to review. I have decided I'm not retelling the many complex tales that are interwoven in this book. Rather, I'm going to comment on legal and other references in the book to explain, clarify, and expand upon. These are references, I think, that as you read, you may have wondered, wow, I wonder what's behind that reference. I'll restate only the storylines necessary to provide context to the issues I'm going to comment on. And I will go in order of the book in terms of the issues that I'm going to address. So I'm going to start with Isaac Foster, who was the pastor. His wife, of course, was Rebecca, who plays a critical role. A sub-story was that he was terminated as pastor and he was suing the town. He had a 5-year contract and he was suing for pay for the balance of the 5 years. He was still living in the parsonage, which was irksome to many in the town, and he refused to leave until the lawsuit was settled. What's interesting to me, and what I want to expand upon for your understanding, is his lawsuit seeking full payment for those 5 years. It happens in our law that when there is a breach of contract, as one party violates an agreement that two parties have, although the non-breaching party, the one who did nothing wrong, in fact did nothing wrong, he or she has a duty in our law to mitigate the loss, minimize the loss. We don't like, as a legal system, economic waste. So, for example, if you're a landlord and you have a 1-year lease with your tenant moves out after 8 months, you cannot just sit back, air out the apartment, and sue the tenant for the 4 months. In order to get those 4 months, that landlord has to attempt to re-rent the apartment, thereby mitigating the loss. There was no reference to this. And I wondered what was in the contract. This really was a minor story, and we didn't get that information. There may have been something in the contract that eliminated his need to mitigate that loss. But know that in today's world, absent a provision in a contract, usually the non-breaching party, and Foster was that here, would have to attempt, in this case, find another job, look for another job, can't just sit back, sue, and expect to get those 5 years. A central issue in the book was whether Rebecca Foster was raped, and if so, did North do it? As a reader, we know the answer to these questions, although courts did not. Today, interesting, we have blood tests and a test done of the baby, and the suspected father can easily determine whether there is a connection. Know that there are rape kits today at doctors and hospital offices. These include a package of items that are used by medical personnel and police for gathering and preserving physical evidence from the victim following a sexual assault. There's DNA evidence that hopefully can be extracted from the woman if she reports quickly, and that evidence has tremendous use in sexual assault investigations and prosecutions of perpetrators. Those kits were developed in the mid-1970s in Chicago. DNA evidence is quite amazing. We saw it first with the O.J. Simpson case. The example that to me garners great awe is involved a case where there was a question in a union election, and some of the ballots were submitted by mail, and there was a question whether those entitled to vote were in fact the ones who had voted. And the DNA from the stamp that was used on the stamp and inserted on the envelope could be obtained and utilized to determine whether it matched the DNA of the person who voted. So DNA is really a powerful way of detecting perpetrators. It is in so many parts of our bodies: hair, saliva, blood, sweat, and other locations as well. Another issue in the book is that punishment should fit the crime. There are different consequences for different levels of crimes. There were, I'm trying to remember how this, it came up. Well, it probably makes sense. Let me hold this till we talk about coverture and then come back. That's where that arose. So hold that thought. There is a reference in the book to accusing and proving are two very different things. And this is very true in law. Accusing is fairly easy to do, though in order to start a lawsuit, one has to swear to the truth of the allegations, the claims that the person is making. But the to prove a case, to win a case, requires proof. This statement came up in the book in reference to looking at the cause of death of Joshua Burgess, but it could be the theme for the whole book, that proof is required. It is what I'm going to call the coin of the realm in court. We saw in the case involving Rebecca Foster, she did not appear for the trial of North, understandably so. She had tried a couple of times in court. She had to give her story. It was humiliating. It was difficult for her. She was very unhappy having to do it yet again. She also was in the very later stages of pregnancy at the time that the trial occurred. But that proof is critical, and she was a critical piece of the truth. There were depositions, which are statements given before trial under oath, and the prior testimony that she had given that were used at the trial. Today, it would be tough to get in those depositions or the prior testimony because of our wonderful right to due process. Tricky in its application here, but due process protects our rights in court. The cross-examination is a key part of due process. It is a constitutional right that North would have had to cross-examine in court before the jury Rebecca Foster. When she didn't appear, that's not an option. The goal of cross-examination is to discredit the witness. It can be done by showing bias, intoxication at the time of the witness, at the time of the events that the witness is testifying to, sometimes poor eyesight, or maybe a person wears glasses and they weren't wearing them. That was a key factor in 12 Angry Men. That was one of the issues that arose during that jury deliberation. Sometimes memory fades. Sometimes there's outright lying. These are all factors that an accused has a right to explore with a witness on cross-examination. Due process today includes much more than cross-examination. It's a very important right to anybody accused of a crime. It includes the right to notice of the charges against you, time and place of a hearing. If you are Harry Potter fans, you may recall in the scene where Harry has a suspension hearing. At the last minute, the judges who were very much against Harry Potter changed the time and the location. That's a violation of due process because you may not be able to find your own hearing. So that right to know the place and time of the hearing, right to an attorney as part of due process, right to cross-examine witnesses, present witnesses on your own behalf, right to an unbiased judge, right to what we might call proportionality with sentencing, that the sentence fits the crime. Due process today is front and center in the case of Kilmar Albrego Garcia, the Maryland man who was mistakenly deported to El Salvador without a hearing. The big issue was due process. Maybe he did what Trump says, maybe he didn't, but he's entitled to due process before being deported. He now is back in this country, and a hearing is scheduled soon. So that due process is an important part of our system. Next, interesting, the laws applicable to midwives. So the book delves into this, very different today. the midwife was required to ask the name of the father while the woman was in labor. This was and this was for women who had children out of wedlock. The name of the law, an act for the punishment of fornication and for maintenance of bastard child, such a biased name even of the law. The father of a child was obligated to help the unwed mother with maintenance, financial support of the child. The law mandating that the midwife ask the name of the father while the woman was in labor was to get that name and help ensure that the unwed mothers had means to provide for the child. In practice, as we learned from the book, it really resulted more in public shaming of the woman than actual holding the father to the requirement of payment. And the assumption of this law by requiring the midwife to ask the woman was that women under the physical duress of labor would not be in a position to lie. Martha Ballard, our lead midwife in the book, says, clearly the men who wrote that law knew little about women and nothing about childbirth. And the laughter from all of the moms. And interesting, another theme of this book was the discrimination between men and women at the time. And if the mother failed to cooperate, failed to reveal, to give the midwife the name of the father, she was fined and had a possible jail sentence. No equivalent or related punishment for the father. The parents today know that both parents have a duty to provide for the necessities of a child until the child is 21. And this right can be, or this obligation, if the parents are not together, can be enforced by lawsuits. And the consequences can be that the non-paying partner can have their wages garnished, any licenses that they have suspended, including both professional licenses and driving licenses, and the tax returns, assuming there's a refund, would go directly to the, usually it's the mother who has the child and the father who is reluctant to pay in these circumstances. So the father's, any refunds from taxes would go to the mother to pay those obligations for maintenance. Another issue has to do with the amount of the fine that a woman was forced to pay and the duration of jail. And we learn that North, when he administered this law and imposed the fine, was not lenient towards women. The minimums and maximums were provided today are provided in law. So a judge has certain parameters in which to impose fines. For example, if I was, when I was a judge, let's say the charge was petty larceny, which is stealing anything less than $1,000. I had the authority to impose a fine anywhere from $0 to $1,000, jail anywhere from no jail up to 1 year, probation, no probation up to 3 years probation, or community service no more than a year's worth of time, home confinement, also treatment. So there are parameters. Sometimes they're large parameters, but there are parameters. North apparently had none and was, as Martha Ballard tells us in the book, not lenient in imposing those fines. Another law for midwives was coverture, what is called coverture. And this was actually not midwives, but women generally, women could not testify in court without her husband present. The exception was the midwife. The midwife could testify to a woman's declaration of paternity, who that father was. But other than that, for a woman to testify, we needed they needed the husband to be present. Another disparity between men and women. So you may remember when Martha Ballard was going to testify at a hearing involving North's rape. North sent Ephraim, the husband, out of town to get a new survey relating to the land, hoping that he would not return in time to testify. And in fact, he does, but up to the minute it took to very close in time, and there was some stress and angst about whether he was going to appear in court in time for Martha Ballard to testify on behalf of Rebecca Foster. No such law today. And of course, with the 12 Angry Men, that movie and storyline was based on women's not being able to sit as jurors. That's why it was 12 Angry Men. Today, of course, women and men can serve equally. Let me go back then with that punishment should fit the crime. Sorry. I think I will. Oh, yes. Okay. So we saw punishment should fit the crime. There's these parameters that judges work within. North was originally facing capital punishment for the crime of rape. Now, this is not relating to this is not relating to the differentials in penalties, but North was facing capital punishment for the crime of rape. Actually, it is. The objective there was to provide a deterrent, interesting, not to the perpetrator, but to an aggrieved husband or brother from taking the law into their own hands. In other words, the husband or brother could be comfortable knowing that the law was going to administer the most serious punishment on somebody who had raped their wife or sister. In the storyline, the court held that this was too harsh a consequence for a case with no witness. So the charge was reduced to attempted rape, much to the distress of those who were rooting for Rebecca Foster. No, interesting, there was a United States Supreme Court case in 2008 called Louisiana versus Kennedy. This was, the court held that the death penalty is disproportionate for any offense against an individual that does not involve death of the victim. And so today, that law would not be in place. Death penalty could not be a consequence for rape. However, a first-degree rape would be the next highest level crime, first-degree rape being non-consensual, of course, and force being used, injury resulting to the victim. And that would be the next highest level of a crime, which could result in 25 years to life of prison time. Another circumstance in the book was failure to pay debts. So James Wall was arrested and jailed for non-payment. Today, non-payment of a debt is not a crime. It is a civil wrong. It can result in a variety of consequences enabling the creditor to get paid, but would not result in jail time. The creditor would be able to take money from the bank account of the debtor, could garnish the wages of the debtor, could take what we call non-exempt property of the debtor and put a lien on real property, but could not send that debtor to jail. We also have a system of bankruptcy where we, as a legal system, say, hey, we have a choice. We could say you created those debts, wallow in it, or we could say we're going to give you some relief, and we do give relief through bankruptcy. It is a process that seeks to maximize assets, liquidating assets of the bankrupt, and then using that money to at least partially pay the creditors. But we would not send somebody to jail for non-payment of a debt. Another issue that comes up is interracial marriage. This involved not Dr. Page, but the female woman of color who went by doctor and sometimes co-administered with Martha Ballard to a woman giving birth. She made this comment, no law recognizes a marriage between your kind, speaking to Martha Ballard, and mine, that interracial marriage. In 1967, Loving versus Virginia, the United States Supreme Court struck down state laws that banned interracial marriage. Richard Loving was white, his wife Mildred was black. The case was a unanimous decision. We haven't seen those of late, but a unanimous decision of the United States Supreme Court based on primarily equal protection. It was considered a pivotal moment in the fight against racial discrimination in the United States, and interesting, was cited in cases seeking marriage equality for same-sex couples, and was cited in Obergefell versus Hodges in 2015, which allowed marriage of same-sex couples. Another issue that involved the Indians and discrimination against the Indians. So this was what motivated North to rape Rebecca Foster, her kindness to Indians. He had fought to rid the area in Maine of the Indians and felt that it was an insult to the town that she would reach out to Indians. We don't know in what way she did, but apparently showed various indications of kindness. And North took that as an assault, given all that happened during the French and Indian War. So those wars occurred between 1754 and 1763. The 7-Year War, there was colonial conflict in North America between Great Britain and France and their respective Native American allies. It ended with most of the colonies in North America going to Great Britain. Lydia was the wife of North. She commented when talking about the rape, do you remember what it was like in Maine before the war against the French and Indians? Joseph, her husband, does. He fought to clear the Kennebec, that's the river area of Maine where this all took place. He fought to clear the Kennebec of, in her words, that vermin. And Rebecca brings them back to this town. She deserves what she got. And that was the North's wife's comment, and rape was his revenge. Native Americans were chased off. We know this history in our country, Maine no different. Off the land, they suffered trading abuses, land grabs, murders, and enslavements. They were blocked from access to hunting, fishing, and foraging grounds. Free-roaming English livestock invaded their cornfields and ate their produce. Ultimately, the Indians had sided with France, and France lost that war, or lost the areas, the property in Maine where this took place. So that was a big part of the motivation against the Indians. One of the tribes was the Wabanaki, which is referenced in the book. They made alliances with the French through fur trade. English colonists wanted to have an agricultural society and saw the Native Americans as competition for that. It happens that the Wabanaki remain well and alive in Maine today. They have newsletters, podcasts, lobbyists. They've expressed great concern about Trump's cuts. Those monies support their community's education, healthcare, and environment. They're also involved with the tourist trade in Maine and the Acadia National Park. Those cutbacks are of concern to how it will impact the Wabanaki community. Additionally, in 2001, there was a law that requires inclusion of Wabanaki history and culture in K through 12, kindergarten through 12th grade curriculum. This has been largely ignored in Maine, and they have lobbied for new legislation that is pending that would fund specialists and advisors to come in and teach the teachers so that the teachers can teach the students. Another issue, the judges' attire. North wore a wig, red silk robes, they said, in the summer, black in the winter, and ruffled collars. I tried to find out why red in the summer and black in the winter. I have no explanation. Today, of course, we don't wear wigs or ruffled collars, but the absence of the ruffled collars is interesting because the judicial robe is awkward for women. It's made to fit a man's collar and tie. Ruth Bader Ginsburg, of course, had all these various collars called jabots. She said, you know, the standard robe is made for a man because it has a place for the shirt to show and the tie, which is correct. For women, it's really you're bare-necked unless you wear something. I always wore a string of pearls that were sort of tight to the neck to round out a aging neck. Another thing in law is discovery. So discovery refers to the time in a lawsuit, which happens before trial, where there is an exchange of information. Our law wants the person who wins the trial to be the one who the facts favor, not the one who had the biggest surprise at trial. So discovery is very important. It's part of what causes cases to seem to drag, but it's an exchange of information. All relevant information must be exchanged, and each side has an opportunity to interview the other side under oath. This comes into play. North, you may remember, tried to get information from Martha Ballard before the hearing in court about what Rebecca Foster had told Martha concerning the rape. Martha's response is, I'm not telling you anything, and I'll see you in court. Today, and that of course puts North at a disadvantage, hard to sympathize with him, but each side is entitled in today's world to full discovery, no surprises at trial, and must disclose all. If there is a surprise witness that hasn't been disclosed to the other side, that witness will not be permitted to come to testify in court. Unless the party couldn't anticipate that witness. Some of you may remember a case in Rochester. There were two kids and they were taking a break from school. They were supposed to be in school. They were driving a car. They hit a driver ed car. And all four people in the driver ed car were killed, 3 students and a teacher. And each of the two, by the time the police arrived, the 2 in the car that had caused the accident had gotten out of the car. and they each said the other one was the driver. And the prosecutor gave immunity to one to testify against the other, used their best judgment. And this case was followed in the news. It turned out there was a woman who had seen it, who didn't come forward, but because she didn't want to testify, but she saw the news and could see that the wrong person was going to be likely found guilty, was the accused, and she came forward at the last minute. So this was somebody whose identity had not been disclosed to the other party, but because she hadn't come forward except at the last minute, and the prosecution, the parties never could have known about her until she came forward herself, she was allowed to testify. But absent a circumstance like that, if one of the parties holds close to the chest a witness and wants to do a big surprise like Perry Mason on TV, doesn't happen. That witness won't be allowed. Interesting, wife testifying against a husband, another issue. Lydia North, she was going to lie for her husband. She had slept the night that he went out to rape Rebecca Foster. She was going to lie. She did lie on the stand and was going to do it again to protect him. Today, there is related a marital privilege, but only for communication. So one spouse cannot testify of a confidential communication given by the other spouse to that one spouse. So the purpose of the law is to protect and encourage spouses to have confidential conversations, confide in each other, trust each other, but it relates only to communications. So in this case, if she wasn't going to lie and was going to tell what happened that night, not anything that North said, but what he did, that would have been permitted testimony, even though they were husband and wife. Preferential treatment. Barnabas Landum, he was the officer of the court. He came to arrest Joshua Burgess, you may remember, not knowing that Burgess was dead. North, however, with the exact same charge, that rape charge, was allowed to return himself into the court. Martha asks why the different treatment. Response was that one is the judge and the other is not. This is offensive to our legal system today. Everybody should be treated equally. It matters not your position in life. The fact that there was no witnesses. This is an issue with all sexual crimes. Normally, there is nobody else present. It's the two parties, and that's what makes these cases so difficult. It gets down to he said, she said. Interesting circumstance here. You may remember that Sally Pierce, who worked for Rebecca Foster, worked for the parsonage, overheard a discussion between Martha and Rebecca, where Rebecca said she hoped her husband had killed Joshua Burgess, and that's Martha's recollection also. However, Sally Pierce, who was listening through the door, claims to have heard Rebecca say, "My husband killed Joshua Burgess," and this became an issue in the trial. This is not unusual that there's conflicting testimony. Jurors have difficult jobs. Jurors are the ones, unless it's a bench trial, jurors are the ones who have to figure out who's telling the truth and who is not. But normally, this was an unusual circumstance that we had Sally Pierce as a supposed witness, because usually it's just he said, she said. You may remember the confirmation hearing for Justice Thomas and Anita Hill, where Anita Hill alleged that Judge Thomas made some very inappropriate sexual comments. Nobody else heard them. Was he telling the truth or was she telling the truth? Difficult. We all have our opinions, and I certainly have mine, but difficult for a jury to make that distinction. I think about now the Sean Combs trial with these freak-offs, no problem there, lots of witnesses at those events. The Kennebec proprietors, this was the issue relating to the property that the Ballards lived in. They had rented property, 3 things required in order to own that property. One was build a house on the land, one was till a minimum of 5 acres, and then live there for 12 years. They had done the first 2 and they were within months on the 3rd when North attempted to assign their lease to Joshua Burgess and thereby prevent the Ballards, Martha and her husband Ephraim, from owning that property. Conveniently, Joshua Burgess died, and so that didn't happen. But there is something akin to this in our law in New York State. If somebody, and it's called squatters' rights, if you live on property for 10 years, continuous without interruption, without permission, it can't work with a tenant. So you have to, as the squatter, you have to not have permission and no notice to leave. And you must be using the property in a way that is open and obvious so that if the owner of the land came by, they would see that somebody's occupying it. If you do all those things for 10 years, no interruption, no permission, the property becomes owned by the squatter. So, and if you own property, be sure at least once every 10 years that you check it out. There is a road on Blossom Road. I don't know the name of the road, but it's owned by a corporation. It's an entranceway to the company, but it also is a main thoroughfare to get around town. And the company enables the public to use it, but once a year, to prevent this from happening, they'll close the street. So now the public's use of the street is no longer continuous for 10 years. So every year they do that to prevent it. I'm looking at our time. I, of course, want to get to the end. So let me jump to that. The scales of justice. We want justice to be equal. We want accountability for crimes. If you do the deed, you should pay the price, and the price should be proportional to the crime. There was nothing proportional for poor Rebecca Foster. She was raped, no question she's going to have post-traumatic stress disorder for probably the rest of her life, impacting her life, her comfort level in her daily living, and her relationship with her husband. We know how traumatized she was. In fact, you remember when the baby was born, she didn't want any part of it. She said, throw it in the river. Her reputation was totally destroyed by old-fashioned views so prevalent at the time that she was sexually violated and therefore disgraced. She was laughed at. She was viewed as an outright liar. Meanwhile, North, her abuser, was acquitted. Big reason was that she didn't testify, and we understand she couldn't. The court should have, because of her pregnancy, adjourned the date. The lawyer should have asked for that. We don't know if that happened. But the evidence is the coin of the realm, and it wasn't there. So it's hard to say that what the jury did was wrong. However, what's missing is poetic justice. So we know that Martha takes the law into her own hands, and she castrates North. He's too proud to admit what happens, and so Martha is not prosecuted and goes scot-free. Great story, many applaud. Author makes her point that the legal system failed Rebecca Foster and many other victims of sexual abuse. Fortunately, today there is the Me Too movement, which vividly shows why women did not come forward. Rebecca Foster's circumstances vividly shows why women did not come forward to tell about their victimization at the hands of many times a well-known, famous man. The male often is someone who is respected in the town, and that in those times, the times of the book, or the zone of influence where the woman wants to have a career. The man is often more believable because of his stature, and she is hesitant to come forward. The Me Too movement provided a safe place for women to come forward. It is a social movement to empower victims of sexual assault and awareness, and it's an awareness campaign against sexual abuse, sexual harassment, and rape. It promotes women publicizing their experiences of sexual assault or harassment. It led to some high-profile terminations. Harvey Weinstein, Roger Ailes, chair of CEO and Fox News for 20 years. Also, Bill O'Reilly, Roy Price, who was head of Amazon Studios, CBS journalist Charlie Rose, Matt Lauer, Garrison Keillor. Additionally, and importantly, the movement provides resources for access to healing and advocates for changes to laws and policies. So fortunately, today there are those organizations that offer assistance and encourage women to come forward so that the confidence that men might have as the usual perpetrators, that what happens between them and their victim is not going to become public, is no longer a confidence that men can have. Know that our law does not allow for revenge. Of course, what Martha Ballard did was outright revenge. That would not be sanctioned in our law. Courts are the remedy. However, self-defense is permitted, and our author wrote into the story not just revenge, but self-defense. Martha Ballard had been thrown from the horse. She was physically compromised. North made it very clear that he intended to brutally rape her. And our law allows us to use that amount of force as is reasonably necessary to repel an attack. So the question then becomes, would that rule of self-defense apply in the case between Martha Ballard and North? How you might think about how would you vote if you were on the jury? Again, the strict law is you can use that amount of force, but not more, as is reasonably necessary to repel an attack. So there's also something called jury nullification. So maybe if we thought the law didn't work, we might think about jury nullification, which is not sanctioned by the law, but neither is it changed by the law, corrected or reversed. It occurs when a jury returns a verdict of not guilty in a criminal case where the jurors believe the defendant has in fact committed a crime, but they nonetheless choose not to convict. This happens when the jury either they believe the law is unjust, or they want to send a message about a larger social issue. The author's explanation, our author is a very popular writer, historical fiction. In fact, she's so committed to historical fiction that in the afternote, she makes it clear, this is not, unlike most of my books, I didn't base this on history. It's inspired by history. And only somebody really concerned about history would make that distinction. And she says 75% of the book is accurate, but 25% is not. She's very concerned about being a historical fiction writer. But she says, I gave North what he deserved. It was not just a little excessive. She finds it excessive. This ending is for every woman who hasn't seen justice in her lifetime. It's not enough, but it's something. And I loved that quote. I would close just a few other remarks. Oh, there's so many interesting other issues that I might have commented on. Midwives, importance of records and diaries. We only have this book, which is also based on, it's referenced in the notes, an actual commentary and the writings of Martha Ballard. We only have it because she wrote and kept those records. I think about the Diary of Anne Frank, another very important recording of one's life that gives us, as those who live after, insights that we wouldn't otherwise have to critical periods in history. Other topics, Shakespeare. If you're a Shakespeare fan, this is a great book. She cites the 3 references in Shakespeare to epilepsy, and then all those chapter intros are referencing Shakespeare. Again, other topics that just not time to comment on. Love of a child, the commitment to her career, got called out all the time in the middle of the night, freezing, riding a horse, because that was the transportation then to get where she needed to go, the commitment to duty, to the duty that her profession of midwife called upon. The historic cameos, Paul Revere, who apparently, if that part is true, I don't know if it's part of the 25 or 75%, but rode on Ephraim's horse, and Thomas Paine. So lots of great issues and fascinating topics and issues that are referenced in the book. I'm happy to answer any questions that you might have. I'm happy to do that. Take it. Do you want to? Yeah.
Is this working? Yes. Okay.
Great talk. Thank you. I have a question about maybe today. If in fact a woman is raped and the perpetrator is found guilty of that rape, maybe through DNA, excuse me, and he goes to jail, if he has assets and she is required to birth the child, if it happens that she becomes pregnant as a result of the rape, if he goes to jail but he has assets, is she entitled to those assets?
In effect,
Anyway?
yes. In effect, it's the child who's entitled to the assets.
Right.
But if he raped and it fathered the child, he's responsible for that child for 21 years, for the child's necessities. Necessities are interpreted fairly broadly, particularly in the earlier years of the life of the child. So yes, she can go after them, and know that family court assists the mother in doing so. And the consequences include, as I referenced, suspension of license, garnishing wages, the tax returns, absolutely.
But if he's in jail.
Oh, well, you said Andy has assets. So if he's in jail and
he's convicted
and does not have assets, then she can get a judgment against him, and that judgment is good for 10 years and can be renewable. So perhaps at some point he gets out of jail, does something constructive, acquires some assets or a job, and then she's entitled. Welfare at some point may become her, if she's not independently wealthy or working herself, then welfare becomes an option.
We probably have time for maybe 2 questions.
Yeah. Make one reference on that. In this course, it takes place in Maine, but it was part of Massachusetts at the time.
Oh, interesting.
And it doesn't, Maine is not spun off into a separate state of Missouri Compromise.
Interesting. Interesting. Thank you.
What is also important is the whole thing about why they're asking for the name of the father is because otherwise the town would have had to pay for the raising of that child. So they're desperate not to have to take
Interesting, interesting.
Interesting.
What would the parameters be for a book to be considered historical fiction?
I don't.
You mentioned the percentages.
Yes, she mentioned the percentage, which is why I said, and I so respected that. To me, 75% for a novel seems like a good chunk of material that's historical and accurate. But to her, that's not enough, and I wanted to make that distinction. I don't know, maybe one of our librarians, great.
I should probably introduce myself. I'm Marion Strobel, a professor of history emeritus at Furman University, South Carolina.
Great, great.
I have taught the actual Pulitzer Prize-winning book, A Midwife's Tale, on which this novel was in part based since it was published like 30 years ago. So, but what is, where am I going with this? Historical fiction. Historical fiction. So what is so interesting about this book, and which I actually really like it, and technically historians usually don't like that, but she takes sections where the real Martha Ballard's diary is empty or she didn't do it. So she's actually kind of filling in where the real story is not, which is what I kind of like about this. So she's adding new dimension to this, and she's giving new dimensions to some of the characters, like her husband Ephraim and her sons and the like. But it doesn't bother me that it's kind of inspired, because she's inspired by sections that don't exist, so she can use her imagination. Does that make sense?
Yeah. Is there one?
Thank you.
Yeah, thank you. Is there one last? I'll come over here.
Is there any special kind of care when a child is a witness? Are the rules any different in terms of what the prosecutor can do?
I heard everything but where the child is.
Is a witness, a young child, say 5 to 7-year-old, in a sexual abuse case, for instance.
So I'm thinking about well, let me answer first. Yes and no. There are certain rules depending on the age of the child, where whether the child can testify under oath at all, or testify not under oath, which is a factor that the jury considers. And then if the judge determines the child is old enough to might know the difference between truth and falsity, the judge, in the presence of the jury, questions the young witness about that. So, and then, if appropriate, swears in the witness to testify. But of course, the age of the child goes to the weight that the jury would attribute to the testimony. I'm thinking about the case with the axe murder in Brighton, and there was she 2 or 3, and now a grown woman. When the trial actually occurred, she was a grown woman, but apparently had no evidence to add, and was, I believe, not in the room when the incident occurred. But that's a local slant on your question. But there are rules that judges have to follow about young witnesses.
Thank you so much, Karen. If anyone is inspired.
Sorry you didn't get your question. Thank you.
If anyone is inspired to check out the book, all copies are checked out. They've been continuously checked out basically since the book came out. Same with The Women by Kristen Hanna, but please stop by the info desk and place a hold so you can get a copy if you'd like. Thank you, and hopefully we'll see you back in 2 weeks for The Women. Thank you, Karen.
Thanks. Yeah. Do I? Yes. You did? Did I?
Karen,
Yes.
2 things. One is, I know you through the business law.
Yeah.
You're still teaching, are you?
I'm adjuncting. I just retired and did.
But I also want to know, is the shipping of these immigrants to Louisiana, is that a violation of due process?
You know, I'm not a student of federal law. So I, the due process violations are very concerning to me. I, I, I don't, it's certainly a new procedure. I'm watching carefully judges' decisions. Every movement Trump makes now is being challenged in court. Um, but I can't answer that. I don't know what the authority would be. Why are we taking them away? This is where they're arrested is where the hearings and the trials should be.
So I think so too. The other thing you were wonderful.
Oh,
It covers so much ground now. But the other thing I was going to ask you was, you know, I don't know about, I taught business law for 45 years or something. But now I lost my thought. Whenever I taught, I always asked, did you see 12 Angry Men? I can't believe the number of students who continue to see it. All through my career, I noticed that's such a wonderful movie.
it's such a wonderful movie. I now require it. I give them the choice. They can either watch Marshall or 12 Angry Men and write about it. Both are excellent movies.
So, yeah.